Hi, good morning, everyone. Um, the agenda for this call is very simple. When you go from curricular practical training to a change of status, for example, into H1, which is the most common practice, um, it has become a standard set of problems that the CPT is questioned and it is looked at very carefully by the USCIS. And I think if I forewarn you, if I can tell you what the government is going to ask you, perhaps you can be better prepared for answering these questions. That can become a problem otherwise for change of status. Let me begin from the bottom up. What if USCIS is not convinced that your CPT, your curricular practical training, was properly authorized, properly maintained, or legal? What happens then? Well, if you are approved for the H1, they would expect you to go outside USA for visa stamping, which is by itself should not be the end of the world, but as a practical matter, it can become quite problematic because at the counselor stage, you don't know how long they are going to hold off your application and whether the employer can sustain your absence for that period of time. So it is always better for us to get our change of status within the United States if we can. And being prepared to answer questions related to our curricular practical training is a major step forward in being prepared for a change of status. Okay. I was telling Mahendraji just a moment ago, I said to him that I actually took out a copy of the relevant portions of a CPT set of problems from an RFE that we responded to just last week. Okay, so this is the most recent information available. This is what the government is asking. Let me go over the elements of what they are looking for. In my view, some of these demands are highly unreasonable. Nevertheless, our approach is always to cooperate with the government and to provide all the information that they seek as best as we can, rather than get into an argument and delay your case. Okay. So where possible, we want to cooperate, and if we cannot cooperate for whatever reason, whether that information is unavailable or whether we don't want to provide that information for privacy reasons, we should be prepared to also fight the government if necessary. So keep that in mind. Now, before I go forward, I want to remind everyone that this call is being recorded and this will be made publicly available. So, by participating in this call, neither you have become our clients nor we are lawyers. This is merely an information dissemination session. And also be mindful if you want to conceal your identity, make up a name. If you ask a question at the end of this call, um, call yourself Sam or Samantha. We are okay with that. You don't have to reveal your identity. That's fine. Okay. That said, let me dive right into it. I have on my unfortunately, I did not share this so far with Mahinderji also, but I'll put this document up on our website in my blogs at immigration.com. You can download a copy or you can see a copy of the sample request for evidence that you might receive. Now, the first part of the request for evidence is, give me one second. It deals with just the OPT side of things. If time permits, I'll come back to those OPT issues, but the CPT issues are technically the more troublesome and more difficult to handle issues. To give you a context of what CPT is, curricular practical training is allowed by the regulations where there is a program in which hands-on work is an essential, and the technical language used in the regulations is integral, where practical training is the integral part of the education. Okay. In one of the RFEs we did a couple of weeks ago, the issue was, no, I think I'm sorry, I take that back. It was actually a consultation I did yesterday. Uh, there was an interesting issue presented. The definition of the word integral was in question. Okay. The the DSO of the school had given a letter in response to an RFE that there are two kinds of um, practical trainings in our school under CPT, those that are highly recommended and those that are required. And the government said we don't consider highly recommended to be integral. Okay, so hopefully, even as we are learning about how to respond to these RFEs, the schools are also learning how to uh, construct their programs so they meet the CPT requirements. So number one requirement, it's integral. It's necessary for you to be able to educate it that you must get practical experience. That's number one requirement. Number two requirement, of course, it's related to your course of study. So if you are studying information technology, the um, the CPT cannot be in economics. It has to be related to your own field. Okay. Um, Third thing, there must be an agreement between the school and the employer that you go to. It's called cooperative agreement. Usually it's just a one-page agreement that says, look, Mr. Employer, the school is informing you that the student who is going to you to work is basically getting credits in school for the work they do, and you have to make sure that they continue working in the area of work that's related to their own major. Okay, so that's a there are three requirements, like I said: integral. And how do they find that out? They look at um, the course curriculum. They want to see the words integral or essential or required or mandatory in the school's curriculum or the school's website, even from a letter from the DSO. So they look for that word. Second thing, as I said to you, was that it has to be related to your major. And third, there must be a cooperative agreement between the university, school, and your employer. Okay, these are the regulatory requirements. But then there is a lot of makeup on these. That's just the face. The face then has makeup. And I'll get into that when I go through the RFE request item by item. Let me interrupt here for one moment. Mahendraji, did you have any area that you wanted me to address before I go on? Of course, guys, I want you to keep noting down any questions that come in your mind. I'll take all the questions in the end after I'm done with the presentation. Mahendraji, did you have anything you want me to? Okay, okay, that's fine. That's fine. Okay, so let me go over the RFE that we received. Number one, they wanted us to provide the following. This one is easy. The course and the course code in which you were enrolled that requires CPT. That's easy enough to do. They're just asking for the course particulars. Number two, documentary evidence that immediate participation in CPT was required. Why does this become necessary? Immediate participation is required. What happens is, normally CPT should be granted only after 1 full year of education. Okay. If you are being given CPT in the very first semester, there are a couple of additional requirements. One, you must be in a graduate program, and two, the CPT must be immediately required. Okay, so they want to see that, and usually it's from a letter from the DSO that says we started work. For example, let's say the student is doing a degree in information technology management, and in order for them to get project management experience, they must start from the very first semester a job that gives them that experience. So some evidence that immediate participation in CPT was required. Okay. This is in those cases where you are getting CPT in the first semester. If you get this letter and you actually got CPT in third semester or so, you can respond, your lawyers can respond stating that this should not be required because the CPT was only given in third semester, not in the first semester. Then third, they want evidence that this was integral. And again, usually what we do is we provide a letter from the DSO as well as material from the university website and from their course materials showing that either the CPT is, the practical training is integral, essential, mandatory, necessary. These are the kind of words they are looking for. If it says recommended, you're probably going to lose out. It may not be possible. Once again, I'm reminding everybody, some people logged in late. The RFE that I'm reading from was a real RFE that we just responded last week. And I'm bringing that out as an example of what you can expect. I will post this on our blog over the weekend, and my blog is at immigration.com, and you go there to see it. Okay. So next thing they wanted to have is a letter from the beneficiary's CPT employer. Imagine this is where employers should pay attention. They want the employer to explain the job duties, pay, period of employment. All of this is geared towards um, making sure that the beneficiary was employed and student was employed in a position or in work that was related to his or her major. Number five, evidence of cooperative agreements. I talked about that in the beginning. One interesting point here, a couple of months ago, we had a case in which um, the university was using a letter in lieu of an agreement. I think it's the silliest denial I have ever had a consultation on. The USCIS said, well, you don't have an agreement, you just have a letter. And of course, my recommendation was that somebody needs to teach USCIS the law that a cooperative agreement is not required to be in a specific format. It can be a letter. Any agreement can be a letter. In fact, when you are given a job offer by an employer and you sign it, that's a contract. Okay. So what I would recommend is if your cooperative agreements are not containing the word cooperative agreement, you may want to have them revised. And if there is a problem, let the DSO call their lawyers. They are welcome to log into our community conference calls also. We have a community conference call every other Thursday. Next Thursday we'll be having one. And I think we start at 12:30. Yeah. Sometimes I go on to 3 o'clock, sometimes 1:30. So it's just, I don't really care what time it takes as long as I can answer everybody's questions. Okay. So cooperative agreement. Now this is the tricky part. A detailed statement explaining how you obtained the CPT employment. Did you get it through school? Did you do it individually or through an outside company or consultancy? This is all a part of the RFE. This is relatively new. What they are doing here is they're trying to focus on whether the CPT is an excuse to get work authorization or, and frankly, I don't see it as a problem as long as you're attending the course, full course load, and everything else is in good faith. Why can't you use CPT as a good device to also work simultaneously? I don't think that's a problem. But cases which are clearly fraudulent or misrepresented could have a problem in this. And again, I warn employers that if you have a situation where you're not sure what you're doing feels right, it's better to check with your lawyers. It's always good to do advanced planning rather than do planning in retrospect and try to take care of things when they go wrong. I'm not worried about USCIS investigations. They are a part of life these days. But I am definitely worried that if the investigations get out of hand, then you have to spend thousands of dollars on attorney's fees as well as go through interruption in your work because you're so preoccupied with dealing with these nonsensical issues. So it's a good idea to plan for it. For the employers, it's important that you make sure that you understand when you're offering somebody an employment that is absolutely above board. There's nothing wrong with individual approaching you and you giving them employment. I think that's fine, but we should be honest about how we got the employment. Okay. Then the seventh point is that we must be able to prove that the CPT is or was directly related to your major area of study. That's a simple enough issue. I don't think that requires too much elaboration. So these were the 7 points that they asked us to cover in the most recent RFE. There are other points related to OPT. There are about 11 points on that. Mahendraji, do you want me to run through them real quickly or just focus on the CPT? I think we have enough time, but I don't know. Okay. Okay. Sure. So on the OPT, what they asked me was 11 points. They said, show me the transcripts. Okay. Whatever you studied at the university that gave you OPT. Show me copies of your degrees and or certificates showing course completion. Show me receipts for your tuition payments. We want to make sure you were paying your tuition. which is kind of odd because no school will let you study if you haven't paid up. Next is number 4 point was receipts for books, parking passes, school supplies for the period of time that you were a student. Student ID, number 5. Number 6, course syllabus, outlines for your program showing what you were supposed to be studying. Number 7, evidence that you were physically attending, such as transportation receipts. If you took the bus to school, if you had confirmed transportation reservations, attendance records at school, any similar evidence that shows that you actually physically attended. Here, the problem is this is a remnant from the Tri-Valley University days, because in Tri-Valley University, one of the allegations was that, and I think Susan Su went to prison on that, didn't she? I think she did. Yeah. So Susan Su was the president of the company as well as the owner of the operation, from what I understand, or what I remember. So the problem was they were doing courses by distance education, and government took objection to that. And there's only a certain number of courses. I think it's one course, 3 credit course maximum you can do per semester through distance education. Check with the DSO. Don't take my word for it, but I think that's what it is. Then they wanted to, number 8 was give us evidence of your residence. I mean, if you were living close to the school, utility bills, rental contracts, receipts, etc. You can even use your credit card receipts for some of these things. Then number 9 was show the number of online or distance education class credits you took. Okay. So again, this is kind of a gotcha or a trap for people and the universities who are making the students or allowing the students to take too many credits online. Okay. 10 is the evidence that you were making progress towards completion of a program of study. That's typically your transcripts. And number 11 was a catch-all, any other documentary evidence that shows you were engaged in a full course of study and working towards program completion. So if you had to take a semester off, let's say for personal or medical reason, you should be able to document that as well. This is what they were requiring for OPT. And for CPT, I've already given you what they had asked for. Mahendraji, I'm open to questions from now on. No, the OPT questions that they had asked for was actually for maintenance of status. I said OPT, but this was basically for maintenance of status. This is kind of a template that they use. It can be applied to people who are in school, and it can be applied to people who are in OPT, even to people who are in CPT. Because all of these issues, all you need to do is change the tense from present to past. They can ask you because evidence of maintenance of status is extremely important if you want to change status within the USA from F1 to H1. So good point. Some of these things appear to be related to those people who are out of school. I'm sorry, who are still in school. But what I'm saying is the same class of evidence will be needed even if you're out of school and they want to question your education. The way it works is before the DSO issues CPT, the cooperative agreement should be already in place. And the cooperative agreement typically, if you just go online on any of the search engines and type cooperative agreement CPT, you see plenty of samples. And the school is providing you that. The school sends you that. It's typically a one-page document that just contains two important things. One, you understand this is for credits, and the student will be getting credits in school, and two, that you will keep them employed in the area of their major. That's the only two things that need to be signed. Well, the question about how much the employers should do and should know is a little tricky. Okay, taking it from the employer's perspective, um, I'm always careful about how much due diligence you should perform on cases as employers. In some ways, the more you know, the more you can be held liable for. Okay. In some other ways, as an employer, if you can prepare the I-9, are you not shielded from liability unless government can show that you actually had knowledge of some wrongdoing? I mean, I'm not saying that you are doing something wrong here as an employer if you have not signed an agreement. But I'm not sure how far you're supposed to go. It's the university's responsibility, really, to issue the contract so that you can sign it. Nevertheless, if you want the employee to stay with you long term, and of course for the student, it is important if they want to change status within the United States to approach the school and say, hey, you're not meeting this requirement. You don't have a cooperative agreement in place. And I think it would be okay to sign a cooperative agreement, but I don't think it should be backdated. So if there's a violation, it's only a technical violation. Government may choose to forgive it, but certainly backdating it could amount to fraud or misrepresentation. Don't backdate these agreements. Okay. Yeah. I think it's okay to say that. Of course, USCIS can question if you find a job through a referral. Um, is it the cart before the horse or the horse before the cart? See, if you have entered the university and the university tells you you need to get practical experience, um, and then you start looking for a job, that's probably the cart and the horse in the right order because you went to school first. But if you already had a job offer in hand, then you went and got into a school that gave you CPT, that arrangement can be questioned. But you don't have a choice. You've got to tell the truth, whatever that truth is. Remember the three lions that you see, actually, there are four. The fourth is in the back on the Indian seal, Satyam Jayate, truth always wins. It's a good idea to tell the truth. You get into trouble after the truth, that's okay, we can handle it. But if we have you get caught in a lie, that's a permanent bar from entering the United States. Any attempted misrepresentation or actual misrepresentation, even attempted misrepresentation in obtaining an immigration benefit is a permanent bar from entering the United States. And there is only one waiver available, which is very, very difficult to get. Not only question, any words of wisdom that you have for me, anything you would want me to know. For example, you found something in your journey through the immigration process that you would like to share with everyone and me, please do so. Star six, Mahendraji? Star six? Yeah, star six, folks. Okay. Guy, uh, I don't believe, I could be wrong about this, but I don't believe there's a limit to how long. And the law does say that if you have had CPT for 1 year, then you won't get OPT. Okay. But I don't believe there's a limit to CPT. I'm not aware of any such limit. That could very well be. I'm not aware of the regulation. I haven't checked the regulation from that angle, so I will not be able to comment about that authoritatively. But at least I haven't seen any limit. I know this, that if you have taken CPT for 1 year, then you don't get OPT for that program. So your question is, can we get CPT if we change programs? If there is a limit to the CPT and we exhausted that limit, if we change our field of study, can we get new CPT? And if there is something wrong with that, I'll have to look into that question. It's never come before me before. Earlier than this, you've raised this issue for the first time for me. I've never seen this issue come up. So I can't say that I have really looked into it. Let me look into it. I will, like I said, I will send you an email. You can update your website, and I'll also update my blog on that. Let me make a note of that. I'll take a look at it. I'll take a look at it. But people should also, people who are married and their spouses are already in the process, should definitely be focusing on H-48Es. Companies who have multinational presence should be looking at L-1Bs very seriously because L-1B standards have changed from August 31st. They have become a very viable option for many, many companies. Many of our clients are now doing L-1Bs where they can. So, yeah. Um, well, the regulation only says that your training should be related to your major. So if you have your major is, let's say, information systems, um, it is not required that you have to take that semester a course in information systems. Okay. So if you're, as a part of your curriculum, as far as I know, you can check with your DSOs. They are really supposed to be the experts at structuring the CPT. Unfortunately, there's a lot of misinformation out there as well. But it doesn't hurt to check with two or three sources. Check with us, check with your DSOs. But there is no requirement that I know that you have to concurrently take a course in the area that you're working in, as long as the major is related to your work. Uh, Here is the interesting thing. I saw this type of issue, not exactly the same issue. First of all, uh, is there a requirement that there must be a course in that semester? I'm not aware of it. This must be a university's internal rule. It is, yeah, it is not something that I've seen brought up too many times before me. So I can't really tell you if it's a universal rule. I don't think it is. Second part of your question is that if I get the CPT, then I drop the course. Do I still have to have that, drop the CPT? Do I still have to have that course? And the answer is, I have no idea. Simply because to me, the requirement itself in the first place is not really mandated by law. Now, I have seen this issue about dropping the CPT come in slightly different context. Um, I think a few months ago, we had a case in which the CPT issues have been coming up very, very frequently. So we are dealing with them a lot more than we used to. A few months ago, there was a case in which somebody started the CPT, then dropped off, and the government still wanted to have all the evidence pertaining to what they were doing, what they were planning to do. So just by dropping the CPT, I was not able to get rid of the requirements the government imposes upon the rest of the showing. Of course, I don't have to show that there is a contract in place if I never joined the employer. But dropping the CPT does not mean that you've dropped the burden of proving that when you started the CPT, it was in good faith. So they can ask for that. Um, because also remember, the CPT is for credits. Okay. The consultation I did yesterday, there was an interesting point in that consultation. There were two reasons. Remember, I told you, I don't know if you were here at that time, sir, but I said that the DSO had used the words that there were two kinds of CPTs, those that were necessary and those that were recommended. So the second point, government didn't like that. Government said there's no such thing as recommended. It's got to be integral. Integral means necessary or mandatory. Okay. Second point that the government said was this. It was a very interesting point. And sometimes they do pay attention to what they are reading, unfortunately, at all the wrong times. They said, your degree required 52 credits to complete. And I remember the numbers because I just did this consultation yesterday. Uh, but you took 54 credits, two towards your CPT. Okay. So that means the two credits that you took towards your CPT were unnecessary. They were not required to complete your degree. Okay, so they are going into that kind of detail. To come back to your question, which is if I drop the CPT, do I still carry the load? And the answer is, well, you carry some kind of burden. They can still ask you what you were doing with that CPT or what you plan to do with your CPT. But as far as finishing that course or doing that course in school is concerned, I personally don't think it's even a requirement. You'll have to check that with the school. Yeah, I'll check. I'll look into that. I'll look into that. I'll update you guys. I'm not sure I follow that question, man. Can you repeat that, please? It's not tied to a course. That's what I pointed out. I said the word integral. It is. It doesn't say it's integral to a course. It says it's integral to the degree. Actually, I can. Yeah, I can. I can give you the exact wording. Exactly. That's what I said. Give me 1 second. I'll read to you the words of the RFE, which actually mirror um, the regulation. So give me a second. They say documentary evidence establishing both the beneficiary's current nature, and that CPT is an essential part, integral part of the beneficiary's degree program. So they use the words degree program. They're not talking about a particular course. Okay, but here is what they did say. The first requirement was the name of the course and course code in which the beneficiary is or was enrolled that required CPT. So even though, and there's an internal discrepancy in this requirement. In our case, it was simple because the major was information technology management, and really all the courses were geared towards information technology management. We could pretty much list all the courses and say all of them are related. So, but I think from a planning perspective, as we get deeper into this, and since we have the luxury to plan, we should make sure that we are able to point to a particular course and course code that says, well, generally speaking, the CPT is required for my entire major. It is integral to the degree program. Okay. But if you look at the courses and course codes, these are the courses in which the CPT is relevant. Now, are you required to be taking it currently when you are doing the course? Probably not, but remember one thing, I told you, what we see in the regulation is the face, then USCIS applies the makeup on the face. In other words, if I were to use the IT language, the regulations are perhaps similar to high-level design, but the actual code that you write comes in when USCIS interprets those regulations, when the USCIS interprets that high-level design. So as we are going forward, they are putting more and more attention to CPT. You are going to see new and newer requirements coming in, and we have to be prepared for all that. To sum it up, I do not believe it is required that you be taking that particular course to which the CPT is geared in the semester in which you get the CPT. Okay, and I believe Right. And I believe that, okay, let me finish. I believe that CPT can be tied to more than one course. Okay. And it's kind of a silly question. And this is USCIS's attempt to interpret the regulations the way they see fit. But there really is nothing in writing that I can point to that says this is the way it's supposed to be. I don't know of it. Frankly, like I said, we never used to get involved in these issues because CPT was something handled internally between the school and the student and the employer. No reason for lawyers to get involved. But more and more, this is spilling into our field. So we are also learning and understanding what they are requiring and what they are doing more and more. Okay, so Mahendraji, I hope that kind of covers the discussion. Yes, it's F1 to H1. Correct. And the consultation that I did yesterday was actually an ex-Tri Valley University student who went from F1 to H1 and is going back to F1. And somewhere along the line, they started questioning his earlier CPT and all those things. So it just kind of is indicative of the government's mood, what kind of questions they're going to ask me when I go before them. That's okay. You can while I'm talking, you can take your time. The first answer is very simple. In my view, a paid employment is not required for CPT. There was a time in OPT last year when during OPT, government said unless you get paid for it, we consider you to be out of status. And we then presented a 50-page brief to the government, which we circulated to some of the officers in the government as well, saying that this is a legally incorrect situation. This is not a requirement of the law. If I want to volunteer time, I can. Of course, there is a problem with the employer. There is a wholly separate issue. Under Fair Labor Standards Act, and this is of interest to all employers, Mahendraji. Under Fair Labor Standards Act, an employer cannot take free work unless you are a non-profit organization or you have a training program which is structured for the benefit of the trainees, but not for you to take work from them. Doing unpaid internships is most probably illegal for the employers. So I said that's a separate issue, and that's not the domain of USCIS. USCIS should only look at whether or not under immigration law it is legal for a CPT or an OPT person. In that case, it was OPT. I'll say the same principle applies to CPT. Um, Needs to be paid in order to be in status. And after denying many hundreds of cases, they actually backed off. From that point forward, we've never had a problem. Okay, so there really is no requirement that OPT or CPT should be paid work. There may be a problem that the employer cannot hire you unless they are a non-profit, not-for-profit organization. But if they're a private for-profit employer, there are some stringent requirements of who can and cannot take internship. So does that answer your question, sir? I am again not aware of any law, and frankly, I would fight for you if the government said you have to be personally present at the job location and you cannot work remotely. As long as you're getting the experience that you need to get and the experience that related to your major, I don't see how the government can make me come to the spot. This is not like attending school where I have to go personally. For CPT, it is my belief that you can work remotely. I don't see any problem with it. Yes, ma'am. Go ahead, ma'am. Oh no, ma'am. OPT, if OPT is given for a program, for example, in information systems, and let's say your undergraduate was economics, you're not required to go into economics, but the OPT that was for the program, that is what is relevant here. If the program was information systems, you've got to get OPT and work in a job in information systems. That is incorrect. That information is incorrect. That is correct. That is, well, accounting could be related to information systems. Yeah, if it was, for example, if I was doing, let's say, accounting software, or I was dealing with systems analysis in an accounting company, I think that's okay. That's related to your field. But if you start doing bookkeeper's work and doing data entry in accounting, that is probably not related to your work, to your major. Look, ma'am, let me just caution you. It's very normal for human beings, including you and me, to keep repeating the question until we get the answer we want. And the answer is still the same. It has to be related to your master's degree, not to pharmacy, which is your undergraduate. Okay? And you're welcome. Anybody else has a question? Yes, ma'am. Okay. Um, okay. Hang on one second. Hang on one second. I'm a little tired of holding the phone against my head. I'm just going to put you on the speakerphone. Give me one moment. Can you guys hear me okay? Yeah. Okay. So the question is, if I'm on CPT and the employer has not been running the payroll for a month or 2 months, what does that do to me? Is that correct, ma'am? That's what you wanted to know? Yeah, I wanted to know what would be the advantages and the disadvantages. Oh, there's no advantage. You don't get paid. You don't have money. No advantage. You can't prove that you were working. No advantage. So there are disadvantages, definitely. Government could question whether this was truly being done, whether you were really working or it's just being, you know, cooked up. Although I don't see how you would benefit from just cooking up time that is really not, if you're not getting paid for it, why would you be working? So let me examine this question from two angles. One angle I've already examined, which is employer's angle. If an employer does not pay you, they probably are on the line. You could actually file a complaint, and Department of Labor would recover that money for you, because we are not allowed. For-profit employers like us, like IT companies, are not allowed to have people work without pay unless under very limited circumstances. So you would probably get paid, number one. From the employee's perspective, if they are questioned like I read through the questions that they ask you these days in the RFEs. They want to see your pay stubs. If you can, all you have to prove is that you were working. I don't think payment is important from your side. Okay, other than a nice feeling in the pocket, payment does not help you in the status. I think work does. So if you were indeed working and you can prove that through whether it's work product or through your employee badges or through your timesheets, I think you are covered. You will be okay. So if you don't get paid for a couple of months, it really is a problem that can haunt the employer, not you. Okay.
This brings in an interesting question, Rajji, about the email thing, for the employers especially. I don't know how many employers out there taking CPT as very serious as much they take as OPT as a responsibility of an employer. I think they give the letters to the students because they're somewhere in the university, and even the students also, they're taking the CPT letter, they're getting it, and they're taking it easy whether to work or not. So it's definitely people are not following what you're saying right now in the industry.
Well, CPT can be a hot button. Unfortunately, I have seen some very odd behavior um, amongst people who are dealing with immigration, even lawyers. We tend to make very irresponsible statements, and I have cautioned people time and again. See, Mahendraji, what happens is most law firms are only filing forms, almost working like form fillers. When you get involved with the fallout, like investigations, FBI investigations, Justice Department investigations, um, the consular KCC investigations, and criminal cases that are filed against companies and individuals because of patterns of abuses, that's when you begin to realize that every little thing has a consequence. So please take these things seriously. Never sign a document in immigration because all documents are being filed under penalty of perjury. I always tell my own clients if I suspect that a document is a gray area document, I will not file it because not only do we lawyers must have responsibility towards our clients, we have a responsibility towards the system also. We need to make sure that our clients know how to follow the law and not treat it casually. CPT should be treated as seriously as anything else. All the forms that you file are under penalty of perjury. Be very careful.
Yeah, go ahead, please. The next question.
Okay, I think the question well runs dry. Mahendraji, I will let you know if I see any major developments so that if we need to do a follow-up call with the students, we can do that.
Yeah, especially please find out and give us an advice on the duration of the CPT.
Yeah, I've got two issues written down here. One is, if I can read my own handwriting, CPT time limits, and then changing majors and getting more CPT. And the second was, is CPT required with a concurrent course going on at the same time? These two things I'll find out for you. It might take me a few days. We are pretty busy right now. But as soon as I find out, I'll drop you an email and I will definitely update the blog on my website as well, immigration.com.
That is great.
Okay?
Anyone, any last question?
Very good. Thank you, guys. Thank you all for being here. Mahendraji, thank you for inviting me. I appreciate it. Ji, pranam. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and you know, it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202 800 8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com,
the period dot, and the application should show up.